Thank you all. There's no honor that I have better in my life than when I get a chance to talk to you all judges, many of whom have become friends over the years. I know this is counting against my 18 minutes, but I'm going to say it anyway. And it's always a joy. There was a judge who I always mention, Harry Spencer, who in 1972 gave me my first opportunity to speak to common law judges. And it was very daunting. Everybody was older than I was. Now people are a little bit younger, some of them, but it's still a lot of fun and enjoyable for me. I love the common law, and many of you know I do a casebook. I do want to mention to you, because you've been very helpful in this regard, we're doing the 11th edition of Prosser, Wade, and Schwartz. If you write a particular opinion and you think it's going to be instructive to law students, please send it to me, because once in a while we've been able to use those because they just fit our new book. I'm going to talk about emerging trends. Dr. Peck will follow me. He just did a great job in arguing the Williams case before the Supreme Court, which they heard the third time. I'll mention it in a moment, but I'm going to speak about punitive damages. I'm going to talk briefly about compliance with regulatory standards, Consumer Protection Acts, and then the emerging sort of amorphous torts, like emotional harm, the real heady stuff. And I thought those are four emerging issues that I know about. And I'm looking at them both from a perspective of a former academic and a person who every day is dealing in the front lines with what is going on in the law. Punitive damages were once sometime, when I taught at school, it was kind of obscure, nobody cared about them, but everybody does now. And there's a constitutional muddle that must drive some of the judges crazy here, because the Supreme Court opinions are not always a mark of clarity. They make the restatement look clear. They have a way about them, and I'm sure Bob will talk a little bit about the cases, but I will. There's Williams, Williams, and Williams, 3 times the same case. The Supreme Court keeps sending it back to the Supreme Court of Oregon, and the Supreme Court of Oregon keeps coming up with some new ideas as to why they don't have to reach the constitutional question. And Bob will go into that a little bit more. But what Williams creates for you is confusion as to when you're supposed to use the conduct of somebody who's not before the court to help either raise or lower a punitive damage award. And the court's rule is easy to state. You're not allowed, members of the jury, to use other victim evidence in calculating the damages. But you are allowed to consider it in terms of determining the reprehensibility of the defendant. Now, if you can slice that potato chip, you're a better person than I am. So they're trying to figure that out. There are some things that are clear from the Supreme Court. There is a clear constitutional right to appeal. That was Oberg. There is a de novo review of the constitutional factors. And the lower court does not get deference. And then there's the 3 basic factors to determine whether the award is too large. Reprehensibility, which is apparently paramount, ratio of punitives to compensatories, and cognate conduct in crime, which is often ignored by lower courts. But if there's a crime that's the same amount, similar, it's kind of hard to weigh, because with crimes there's jail time. But if it's a fine of some type, you're supposed to look at that. But they're incommensurables, and it gives you a lot of room to run. The future, I think the court will try to clarify some of these rules, but it's not easy. It's Justice Scalia and Thomas have always bowed out of all this, especially substantive due process. I think we'll get some clarity in the next couple of years, but it's still going to be challenging. But something that the Supreme Court did that I think in a way is more important. Nobody likes mandates. Nobody likes to be told what to do. And when the Supreme Court enters a common law area, many judges, many of you have told me, you know, frankly, Victor, I don't like it. But the court this past term came down with a decision that I read and then reread, and all of a sudden I said, this is like the common law. And this was the Exxon Valdez case, and it's discussed in an article that's in your materials. It's like the common law. They had an outliner verdict, $5 billion with about 500 million compensatory awards. And there are outliner verdicts that are just too way out there. And what do you do about them? Well, common law judges have used verbal standards. And since I was a little pup in law school, verbal standards were the rule. Does it shock the conscience of the court? Well, you know, Bill Clinton's conscience, absolutely, is different than John McCain. Yes, that's true. So it's a very, very subjective standard. And very careful work by Justice Souter, who was acting like one of the state Supreme Court justices. That's just the way he spoke, looked at verbal thresholds, and he would find cases that were almost exactly the same case, like the case with the repainting autos. One jury awards $2 million punitive damages, another jury awards nothing. And he said that verbal thresholds, just don't work. Then he looked at maybe having some type of cap, the way criminal fines are capped or criminal sentences are capped at some measure, so there would be equal justice under law for everyone. But he found criminal rules do not work that well with tort law because, first, if they're fixed in amount, they don't account for inflation, and they may not account for the variability of the wrongful conduct of the defendant. And then he went into a very interesting and careful analysis of data. And he found that among debates that sometimes I have with Bob or others about how important punitive damages were, in a way, both sides were right and both sides were wrong. That there are not that many punitive damages that are off the wall. Most are not. But there are these outliners. And if you look at all of them and the best data that we have available, it comes down to a little bit less than 1-to-1. In other words, if you look at all the cases, punitive damage awards are usually less than compensatories. That may surprise you, but the data is in Justice Souter's opinion. And he developed a rule, and he said in most cases, where you don't have very extreme conduct on the part of the defendant, it's not intentional, 1-to-1 is a good guideline. And I commend the decision to your attention. State judges have looked to non-binding, and this was an admiralty case. It's not binding on you. It's just like a fellow Supreme Court justice in another state. It's something to consider. And lower courts and state courts have adopted many of them. Daubert, we're going to hear that later this morning. Daubert was under federal rules of evidence, but state courts have followed it. Many state courts have followed Metro North, a case I'm going to discuss very quickly on medical monitoring. Sometimes the court, in its federal supervisory rule, comes down with a decision and you welcome it. But it's up to you. There's no mandates. You're not forced to. I just say it's an interesting thing to look at because it does deal with a problem that's vexed every judge that's ever had a punitive damage case, and that's what do you do with the outliner verdict. And Souter's careful opinion is worth careful attention. The second issue I want to mention is preemption. In Washington, maybe this gets where I'm from to say it, but there is all these rumors. I came down, now they want a job for President Clinton. I mean, this is, I guess so they know what he's doing, I guess. And they said Solicitor General. Now I was leaving, they said General Solicitor. Yes, I think I would like to do that. It's just, takes a while, which leads to preemption. So the preemption is, means, once again, if they find federal preemption, that you must do something, that you have to, are forced to follow federal guidelines. And there's express preemption, and the court has made, Supreme Court has made pretty clear that in medical devices, there is preemption and it's express. When you have a warning with a drug that's accompanying a prescription drug, it's less clear, and that's implied preemption. And most of the cases deal with, is there a real conflict so that you cannot exercise and follow federal policy and at the same time allow a warning to be really the product of the imagination of a plaintiff's lawyer, or a view that the drug should not have been sold at all. And it is filled with tension. It's a major issue. I think preemption is not a horrible thing as long as the agency has done its job. But that's not what these cases are about. They're looking to the intent of Congress. And did Congress intend to preempt? And then you must follow it. And it's created a lot of confusion. My article discusses it a little bit. I'm just going to share with you this morning what is my theme, and that's the majesty of the common law. separate from federal preemption, where if there is preemption, as a lower court judge, you must follow it. You have an opportunity to look at regulations through the perspective of the common law. And the new restatement third of products liability, in my outline, it's section 4, common E, has an interesting thing. Their general rule is that if there is compliance with a federal regulation or a state regulation, that's merely evidence that you can tell the jury about. But there are certain regulations that have a greater glow to them, that are more important. And the restatement comes up with certain factors. First, that it's current. It's not from 1854. And second, that the regulatory standard addresses the very issue that's before you, the precise issue. And finally, that was arrived at by a deliberative process by which safety standards was given a full, thorough, and substantial expertise to develop it. So once again, it's the majesty of the common law. Just like you can, if you wish, follow the reasoning of the Exxon case, you can, if you think it's correct, say that there are certain standards that do deserve preemptive effect or do deserve the effect of being a defense. This is not because the federal government tells you to do it. This is because you, as common law judges, which you all are, think it's the right thing to do. And there are certain regulations that do meet that test. I'm not going to say what they are because that's something that's up to you as a common law judge. But I'd commend the restatement to you and looking at it carefully and that perspective. Again, different from preemption. I would mention that in Washington now, this issue is going to be before Congress. There's going to be an attempt by persons, plaintiffs' bars, some consumer groups, to try to overrule Supreme Court cases on preemption. It'll be one of the B-plus issues and quite lively in the next Congress. The third, and next to my final key issue, is Consumer Protection Acts. If you said, all right, Victor, what do you hear the most about from clients? Where do you hear the most angst? Where do you hear the most drumbeats from the various clients that you work with? It's Consumer Protection Acts. They were written to help consumers. They were written to protect individuals. They were written to help avoid fraud at the very close state level. You have the FTC. It's in Washington. It can't monitor everything. And individual states, Indiana, all the states that are here, need to have some type of additional consumer protection. All that is well and good. But when these laws were enacted in the states, I believe careful attention was not given to a crucial question that every judge in this room can understand. There is a big difference between the state enforcing something and the power of the state attorney general in a private lawsuit. They're different. Private lawsuits focus on compensation. Private lawsuits focus on somebody who's been hurt. The majesty of the tort system is to open the doors to people who have been injured where somebody has had a degree of responsibility that they should pay. That's Torts 101. But many of the state legislatures didn't think about this and simply created a private cause of action in the Consumer Protection Act and left a lot of questions that are ambiguous and uncertain for you to resolve. And we have an article called on this topic, which goes through the almost every issue that you would want to think of, called Common Sense Construction of Consumer Protection Acts. And if you agree with it or disagree with it, it's indexed and it has the issues there. They're all over the place. I'll just mention some right now. But think of the theme. The theme is my ruling appropriate for a private cause of action, not a state attorney general? So if there is a drug ad and it's directed to the public, does that mean that the Consumer Protection Act is going to govern other rules, rules that you follow all the time? For example, that warnings are to be made to the doctor. It's a close question. Are we going to abandon this learned intermediary rule? If the warnings in the ads have been reviewed by the FDA and information has been given to the doctor, I don't think that the Consumer Protection Act means that you nullify a common law rule. Our articles discuss that, but that is likely to come in front of you, and one of the problems is somewhat thorny with Consumer Protection Acts. When there's another regulation that's exactly on point and it controls the very issue before you, that regulation, we think, should govern. Consumer Protection Acts were not enacted to just trump on every other field of law. If insurance is highly regulated and effectively regulated, Consumer Protection Acts should stand aside. Many states are very explicit on that point. Should you give money to somebody who's never been injured? That, to me, is a no-brainer unless the statute forces you to do it. A private cause of action is about somebody who's actually been hurt, who's actually been injured, who suffered something. And that also tokens that the person at least should have seen the ad and shown some reliance. In the couple of minutes remaining, I'll just mention the last point, which is stretching the common law for more amorphous damages. If I still did plaintiff's law, and I did for 14 years, this would be the ballpark in which I would want to use my imagination. Again, appealing to you as common law judges. There is time and again an effort to award money for somebody who has mental suffering, but no manifestation of it whatsoever. There's no doctor that can tell you any symptom that he or she has. I think that's just a complete bramble bush for the common law. Professors Tversky and Henderson have explained why. Most courts have rejected it. Medical monitoring. Courts have been divided on this, but most of them say no. And it's interesting, when they say no, they cite a Supreme Court case called Metro North, which was an FELA case. But the reasoning is very powerful, that it's hard to tell when medical monitoring is appropriate, what are the criteria for who gets it and who doesn't, how do we assure that that money goes to a victim? Aren't these legislative considerations? And our view is no, and most of the courts have said the same thing. Some of you have been kind enough to cite some of our articles on that, and most of the states are saying, hey, that's an attractive thing, but that's not for us. The final one, maybe is sort of my favorite, I'll close with this. Some lawyers have decided, and some groups, that when a pet is injured, you should get money for loss of companionship. Now, I come into this with a pro view, because I have Kylie the dog. She is my dog. She is a yellow lab. And if anything happened to Kylie the dog, it's probably the only thing that would get me really, really mad. It's hard. My personality doesn't get that way. But I love that dog. Now, I spoke with her before. I mean, she was there, and we chatted. I said, I'm speaking to all these judges, Kylie the dog. And what do you think about loss of companionship? And she was very instructive. She said, first of all, I don't think money would make you feel any better if you lost me. She had a point there. And second, wouldn't it make the vet costs of my veterinarian go way up and you wouldn't take me right away? She had another point. And what about my medicines? And finally she said, maybe they would take my toys away. So I've come out after listening to Kylie the dog and think that loss of companionship is really not an area to expand the common law. You have that great obligation and great duty to mold the common law of this nation. The last article that we cited is called Neutral Principles of Common Law, Development of Tort Law. And it tells you you can do what you know you can do. You can move the law toward the defendant or toward the plaintiff. And it gives you some thought as to when you want to move it. It's the only article of its kind to try to pick out the criteria of when the law should change. But you don't need the article. You just might find it of interest. Thanks for listening, and if there are questions, I'll be happy to take them.